Today we are going to talk about the landlord-tenant relationship. We want to know how the law governs both the landlord and the tenant. What are some of the obligations and their rights? What does the law say when the tenant defaults payments? What does the law say when the landlord wants to evict a tenant? What's the right procedure of evicting a tenant? So we are going to summarize the landlord and tenant relationship. A landlord-tenant relationship is governed by the Contracts Act, the Landlord-Tenant Act. So we are going to bring out some of the main obligations and rights of both the tenant and the landlord. The landlord is not allowed to ask for rent of more than 3 months at once, and this applies to the monthly tenancy. Then secondly, a landlord is not allowed to increase rent at a rate of more than 10% per annum, meaning that if you're paying rent of 500,000, calculate the 10% of 500,000, and that is 50,000. So the landlord is not allowed to increase rent per annum of more than 50,000 of that year. And in case they have intentions of increasing rent, they have to avail you, the tenant, with a 60 days notice informing you about their intention to increase rent. And this can only be done once in a year. It has to be done only once according to the law. So what happens in case of default in payments? The landlord has two options. One is to evict the tenant. But how do they evict the tenant? They need to provide the tenant with a notice in writing informing them about their intention to evict the tenant, and the tenant has to abide. And the notice has to be of no less than 30 days. But it also depends on the period the tenant has spent on the premises. So, in case the tenant defaults in payment of rent, the landlord is required by law to write a demand notice informing the tenant to pay the rent arrears or else vacate the premises. Then the other option that the landlord has is the option of exercising re-entry, but this has to be done cautiously. You cannot wake up one morning and re-enter the premises that are occupied by a tenant. After giving them notice, you need to inform the local authorities such as the LCs and the nearby police of your jurisdiction. So these authorities, the local leaders, have to be around when you are re-entering the premises to avoid any conflicts that may arise. So to the landlord, in case you want to evict your tenant, you need to provide them with a notice of eviction, and you need to involve the authorities in case you want to exercise the option of re-entry. So in case you are evicting a tenant, how then do you recover your money as a landlord? You can file a case in court under small claims if the amount you're demanding the tenant is below 10 million. But in case the amount is above 10 million, then you have to file a summary suit or a case in the magistrate, grade 1, or in the chief magistrate, depending on the amount you're demanding the tenant. So that is how you can recover your money as a landlord. But get to know this, that evicting a tenant does not exonerate them from paying their rent arrears. You can always, after evicting them, you can always file a case against them in court in order to recover your money and the damages that you incurred. So basically, that's a summary of a landlord and tenant relationship, how the law treats both parties, and those are some of their rights and obligations.